Yo, Judge Subramanian, what's up, man? Check this out. Check this out. So, now, prostitution from a federal standpoint. Now, we just saw that in Long Island, New York, 3 people were indicted and pled guilty at the state level, not the federal level, for running a prostitution ring. They were requiring the girls to pay up to $6,000 to $12,000 a month. They were managing the ring, and they pled guilty. This was a legitimate, corrupt organization. This would have fit into the framework of a corrupt organization, a racketeering, corrupt organization. These guys are lucky the feds didn't pick that up, because that is purely a RICO case. Is when you set up a separate enterprise, a separate situation, where you go into it with the mens rea, with the intent to commit crime and make money, right? But they didn't get busted for RICO. One guy was a cop. The cop pled guilty to managing a prostitution ring, a Class D felony. He received a 1-year sentence for that charge. 12 months at the state level. The girl, the female who was also involved in managing the girls, the sex workers, she got 6 months sentence. 6 months. Now, this was a real prostitution ring. Puffy's is not a prostitution ring. You know that. We all know that. The whole world knows that. Cassie was his lady. This other girl, he was just hitting that. But they were all consenting adults. They all enjoyed this type of, as they put it in the language here, voyeuristic behavior. They were swingers. They liked that kind of stuff. You know, sex with multiple partners. There was no for-profit gain. There was no for-profit gain. There was no for-profit gain. Puffy did not make no money on this. And the 2 girls who were considered his girlfriends were willing participants. There was no force, there was no coercion. Now, Judge Subramanian, check me out. This is page 21 of 62. This is Alexandra Shapiro. I think this is Alexandra Shapiro. Let me see. Let me make sure. Yeah. Alexandra Shapiro wrote this. This is memorandum of law in support of defendant Sean Combs' renewed motion for a judgment of acquittal and a new trial. So this is the motion for Rule 29 and a Rule 33. All right? Page 21 of 62. Document number 486. Page 10 of the document, but page 21 of 62. Judge Subramanian, check me out. The Department of Justice has long declined to enforce Caminetti and Cleveland. Now, what that means is this. The feds, the Department of Justice, issued a dictum. They issued a understanding that assistant U.S. attorneys or U.S. attorneys, United States attorneys, shouldn't even bring no charges for a prostitution case in the courtroom unless it is a for-profit commercial enterprise or there is trafficking involved. Whereas there is a language barrier, and the girls being trafficked are from a foreign country, don't speak English. When they get here, the traffickers take their passports, their visas, their paperwork, and tell them, yo, you gotta sell that kitty cat, you understand, if you want to get your papers back. That's force, that's coercion, that's trafficking, right? And they're making money off the girls giving up the kitty cat, right? That, and only those types of cases are the cases that come before in a federal court. Now, page 10, this is Alexandra Shapiro. Given the intervening changes in both the statute and Supreme Court precedent, it is highly doubtful that the Caminiti in Cleveland remain good law. In part for that reason, even before the 1986 amendment, and the DOJ came down with this in 1986. I was a senior in high school in 86. I was a junior and a senior. The government itself has long declined to prosecute non-commercialized acts of mere voluntary prostitution. Judge Subramanian, for over 75 years, the Department of Justice has stated that the Mann Act enforcement should be limited to cases targeting defendants who violated the statute for commercial gains. This is a U.S. Attorney's manual. This is a U.S. Attorney's manual. For example, the 1953 version of the United States U.S. Attorney's Manual stated, the White Slave Traffic Act makes it an offense knowingly to transport any woman or girl in interstate or foreign commerce or in the District of Columbia or in any territory or possession of the United States for the purpose of prostitution, debauchery, or for any other immoral purpose. Specifically, Judge Subramanian, it says woman or girl. Commercialism is not essential to a violation of the act. Caminiti, United States, however, as a general rule, prosecution should not be instituted in the so-called non-commercial cases. This policy of not prosecuting non-commercial cases continued through the remainder of the 1900s until the focus of the statute turned to cases involving minors and or sex trafficking in the 1980s. Thus, the 1961 U.S. Attorney's Manual stated that prosecution of persons who are not engaged in commercial prostitution enterprises as panderers, operators of houses of prostitution or call girl operations, and those who act for or in association with such persons should not be instituted without the prior approval of the criminal division. In 1966, the Attorney General flatly stated that the Mann Act is designed to deprive those engaged in commercialized prostitution of the use of the facilities of interstate commerce. In the 1970 and 1984 manuals continued to require consultation or approval from Main Justice for any prosecution of individuals not running commercial prostitution enterprise. In 1988, enforcement priority shifted to cases involving sex trafficking and minors, yet non-commercial cases remain deprioritized. Unless minors are victims, unless minors are victims, prosecutions under 18 USC 2421 and 2422 should generally be limited to persons engaged in commercial prostitution activities, even though commerciality is not an element of the offense. Prosecution of persons other than those engaged in commercial prostitution enterprises as panderers, operators of houses of prostitutions or call girl operations, and of those acting for or in association with such persons should not be instituted without the consultation with the general litigation and legal advice section unless minors are victims. That directive continued through the most recent iteration of the U.S. Attorney's Manual, and today the Justice Manual, which replaced the U.S. Attorney's Manual in 2018, makes clear that the prosecution of customers involved in 18 U.S.C. 2421, like Puffy, is now limited to prosecuting those who engage in commercial sex with victims of sex trafficking, in addition to those who otherwise perpetrate or facilitate human trafficking offenses. So, Judge Subramanian, man, what do you want me to do? You got everything there, man. This is a Rule 33. This is a new trial. This is a new trial because there was no commercial gain in Puffy's 2 Mann Act charges, 2 Mann Act convictions. One conviction, is the statute of limitations still available for Cassie? There's a 5-year statute of limitation on Cassie's charge. The last time Puff saw her was in 2018, and he hit it. It wasn't a freak off. He was hitting it. So, free Puff, Judge Subramanian. It's the right thing to do. You have the legal ground to stand on. You may not be popular amongst your peers or those in the Southern District of New York, and that's fine. But it's not about being popular. It's about being right and going according to the letter of the law and doing the right thing. Free Puff. Free Puff. Free Puff. Peace.